Welcome to Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our website is libertylawtalk.org, where you can subscribe, comment, find other episodes and links relevant to today's conversation. Our email address is mail@libertylawtalk.org. We'd love to hear from you. Today we are talking with Clint Bolick, Vice President for Litigation at the Goldwater Institute, about his new book, Death Grip: Loosening the Law's Stranglehold over Economic Liberty. As I mentioned, Mr. Bolick is the Vice President of Litigation for the Goldwater Institute, where he litigates on behalf of school choice, freedom of enterprise, and private property rights litigation, as well as challenging corporate subsidies and racial classifications. Before that, Clint Bolick was the founder of the legendary Institute for Justice, which in that capacity he litigated on behalf of the Cleveland School Choice Program, defending it successfully in front of the Supreme Court, that case being Zellman versus Simmons-Harris. Also, Mr. Bolick is the author of several books, including one that we're talking about today, and also David's Hammer, the case for an activist judiciary. Mr. Bolick, welcome to Liberty Law Talk.
Richard, it's a great pleasure to be with you.
Great, we're thrilled to have you. Let me ask you, before we get into your book, which is excellent, by the way, with regard to litigating on behalf of economic liberty and your time that you've spent doing this, where have we been regarding these problems? Where are we now, and what remains to be done?
Well, my first case challenging a barrier to enterprise under the 14th Amendment was back in 1988, and we won that case in federal district court, and it was at that point, it was the first time in about 50 years that a federal court had struck down a barrier to enterprise as a violation of the civil rights that were guaranteed by the 14th Amendment. Since then, the Institute for Justice and some other groups have won probably about a dozen cases around the country. And we're doing what Justice Scalia urged us to do before he was a justice, when he was back at Chicago Law School. And he said it's essential to reestablish the ethos of economic liberty. We're taking these cases, we're creating building block precedents, and I think we're beginning to get closer to the goal of getting one of these cases to the U.S. Supreme Court.
Okay, excellent. Let me ask you this question. Your book, Death Grip, looks at, in large measure, the Slaughterhouse cases, the infamous Slaughterhouse cases. If little known for those who work in constitutional law and teach constitutional law, surely this is something they're aware of. However, the controversy is usually taught, I think, largely as privileges and immunities meant something different for being for a state, for your citizenship as a member of a state, and your citizenship with regards to the federal government. Before we consider the case in depth, Slaughterhouse stands for what proposition?
It stands for the proposition that the Privileges or Immunities Clause of the 14th Amendment, which is the first of the protections of the 14th Amendment, with equal protection and due process coming after privileges or immunities. The case stands for the proposition that guarantee really amounts to very, very little, that only rights that are established in the original Constitution, such as access to the ports and things of that nature, are protected against abuse by state governments. And as a result, until recently, there was not a single state law that was struck down under the Privileges or Immunities Clause, even though, of course, there have been hundreds, if not thousands, of laws that have been struck down under the other two provisions of the 14th Amendment.
The Slaughterhouse cases go back to 1873, and you write also about a case 50 years prior to Slaughterhouse, Corfield versus Coryell, which was decided in 1823, which adds a lot to our thinking, at least about the Privileges and Immunities Clause. Let me ask you, in the Slaughterhouse cases, what's the statute in controversy? What does it do? How does it alter the slaughterhouse industry? And who are the plaintiffs in these cases?
Well, the law was basically aimed at regulating the slaughterhouse industry, and there were two things going on in Louisiana that led to the law. One was deplorable conditions as far as slaughtering cattle. Apparently, the rivers surrounding New Orleans were just filled with carcasses of cattle, and it was extremely horrible in terms of the health and safety situation. And the other thing that was going on that led to these laws, and I know this is going to be a shock to your listeners, was widespread legislative bribery. And what happened was that Louisiana responded to the slaughterhouse problem not merely by regulating health and safety, that is, the location and the conditions under which cattle would be slaughtered, but by establishing a monopoly which had the effect of putting a number of independent butchers out of business. So if you were going to slaughter cattle, you had to go to the monopoly slaughterhouse, and members of the state legislature were given shares in the slaughterhouse monopoly. That's how blatant the bribery was. So you had both a legitimate issue that needed legislative correction, and as it is prone to do, the Louisiana legislature going a little bit above and beyond and padding the pockets of certain favored business people and their own pockets as well. And so, and you asked who the plaintiffs were. There were a series of cases that were filed, and most of the plaintiffs were butchers who had been harmed as a result of the establishment of the monopoly.
Okay. Now, the 14th Amendment, as many know, is the subject of immense debate. There's an immense amount of scholarship around it. We're aided, and of course, things are made perhaps even more difficult with the written record we have of the debates of the framers who produced the text of the 14th Amendment. How do we get our hands on what they meant by privileges and immunities? Do we have something clear in that congressional record? Do we need to go even further back? I mean, the ultimate origin of the privileges and immunities clauses is in the common law. So
yes.
How should we understand privileges and immunities to mean that which is in the common law, provided that where the framers in the 39th Congress wanted to, either deviate or add to it, they would have said so?
Well, that's really a great question. First of all, it's important from an historical context to understand that even though the concept of privileges and immunities is very, very poorly understood today, it was not poorly understood. It was back in the 1870s. It was very much a term of art. In fact, it was as common as the term life, liberty, and the pursuit of happiness, and it had a very, very defined, a very defined meaning. It essentially was, as you indicated, the common law rights that were well established prior to the establishment of the United States, and that American citizens brought with them from the United Kingdom. And so prominent among them were the economic liberties. For example, under common law, it's impermissible to have government monopolies and to excessively restrict freedom of enterprise. And those were the sorts of rights that were thought of when the Ninth Amendment was placed in the Constitution. And you mentioned a decision, Corfield versus Coryell, which was decided by Justice Bushrod Washington, who was George Washington's nephew. And he explained that essentially privileges and immunities were the natural law rights, or the natural rights of individuals that preceded government and that continued to belong to the American people.
Now, with regard to the 14th Amendment, It seems there's also, in terms of adding flesh to it or adding to the historical narrative, the Civil Rights Act of 1866, and concern that it could be legislatively repealed, owing to majority anger within the Congress at these rights. And so the 14th Amendment is a way to constitutionally enshrine the enumerated rights in the Civil Rights Act of 1866. Am I right in that regard, and does the court in Slaughterhouse take that into consideration?
You were absolutely correct about that. And the Civil Rights Act of 1866 was a response to a particular problem, which was a series of laws called the Black Codes, which were adopted by Southern governments in response to the abolition of slavery. The Southern governments were apoplectic that the newly freed slaves were selling their labor and selling their skills, and they wanted to establish a regime that was not de jure slavery, but what we might know as de facto slavery, where blacks would have very few economic opportunities. And the methods that they used to achieve that were violating freedom of contract, not allowing blacks to execute contracts, to own property, and to sell their labor. And so the Civil Rights Act of 1866 was designed to protect those economic liberties, freedom of contract, property ownership, and freedom of enterprise. If only, by the way, we still thought of civil rights in those terms today, I think our nation would be profoundly different. But that is how the framers of the 14th Amendment thought of civil rights, essentially the right to control your own destiny. Andrew Johnson, who was president at the time, questioned congressional authority to enact that, and as a result, the Civil Rights Act was constitutionalized in the 14th Amendment, with those substantive rights being protected as privileges or immunities of citizenship. The majority in the U.S. Supreme Court really gave short shrift to the Civil Rights Act of 1866. The dissenters did talk about the Civil Rights Act of 1866 quite a bit, and they pointed out that the 14th Amendment as a whole was supposed to amount to really a new Magna Carta, and that after all, a civil war had been fought, so it would be crazy to think that nothing significant was intended to be protected by the Privileges or Immunities Clause.
The Privileges and Immunities Clause, so the court in Slaughterhouse, they don't necessarily take issue that, say, right to contract or the ability to sell your labor is protected by privileges and immunities, but they're drawing a different standard as that applies to the states under the 14th Amendment and saying, as you were saying earlier, it's a couple of broad things, but nothing that specific. Am I right?
That's right. Yes, the majority. It's a bit of a bizarre decision in that the majority acknowledges that freedom of enterprise is a privilege or immunity, but what the court said was that it's not a privilege or immunity of national citizenship. That in order to protect those liberties, people still needed to go to state courts to protect themselves, and of course, it was the state courts and the state governments that were violating those liberties in the first place. So it really gave, it gave lip service to the concept of privileges or immunities, and then eviscerated the protection.
So this case, decided in 1873, how should we understand the fallout, and how is that, how has the river that flows from this decision influenced the course of economic liberties and protection of economic liberties in the federal courts during the 20th century?
Well, it's had enormous fallout. It's certainly one of the worst decisions in the history of the U.S. Supreme Court. First and foremost, it has relegated economic liberties to the lowest tier of judicial protection. I point out in the book that if you receive a welfare check and the government takes it away, you can tie the government up probably with publicly funded lawyers representing you, under the Due Process Clause, you can tie up the government in knots. But if the government decides to regulate your profession out of existence or to impose all sorts of conditions on the exercise of an occupation, it really can do so with impunity, and that's because of the Slaughterhouse cases. There were some other ramifications as well. When the separate but equal laws were put forward, they really should have been unconstitutional under the Privileges or Immunities Clause because, after all, it was an economic transaction. It was people trying to buy tickets on streetcars and that sort of thing, and the streetcar industry actually bankrolled the challenge to these laws. But because the Privileges or Immunities Clause had been destroyed by the U.S. Supreme Court, they had to use the Equal Protection Clause to challenge separate but equal laws, and that was very tough to do because separate but equal laws were known to the framers of the 14th Amendment when it was enacted. So the idea that there should be social equality was alien to the court at the time, so we ended up with Plessy versus Ferguson. And then, the real bottom line was something I alluded to earlier in terms of the fallout, and that is that our conception of civil rights as fundamental natural rights, the opportunity to lift yourself by your bootstrap, that really has evaporated over time, and it's been replaced with political equality. And I think that's had enormously bad ramifications for us. And I think that if the civil rights that had been intended to be protected by the Privileges or Immunities Clause had been enforced in the Slaughterhouse cases, we'd have a much, much different and much better and much freer society today.
It is interesting to think of, say, the Fair Labor Standards Act and the ability to think about right to contract there, where the owner of a company can be, largely compelled, the way I understand it, into under collective bargaining into doing business with, a union group under circumstances that would be the exact opposite, I think, of freedom of contract. And what this brings to mind is, as you say, an altering sense or an altered notion of the sense of property. Property rights and property in your labor. And even going further, I think it's Charles Reich's book in the 60s, The New Meaning of Property, or The New Sense of Property, where he argues that it actually is things like government benefits or your union provided job or things like this. This is actually should be how we think about property in a collective, interdependent sense, and that, of course, going to, as you mentioned, really, attenuating a robust sense of economic liberty. I wanted to ask you a question about the minority dissent in Slaughterhouse. And there's the way I read it, there are 4 justices that joined. It's a 5-4 decision. Is there a middle ground in these dissents, or do we have 2 absolutes playing out against one another?
I actually think that the dissenters were very moderate in what they were seeking in terms of a judicial standard. And there were 3 dissenting opinions encompassing the 4 justices. And I can't emphasize enough how unusual this was for that time. In fact, today, you're surprised if a decision isn't 5-4, but in those days, I can't think of another case that was 5-4. There were very few dissenting opinions, and if there were, like in Plessy versus Ferguson, it was an 8-1 decision. But the 4 dissenters here could not have been more passionate, and I think they were painfully aware of what was going on here, that essentially the court was erasing a part of the Constitution. And so they were very passionate, and they were very vehement. One of the dissenters said that the right of free labor, one of the most sacred and imprescriptible rights of man, had been violated. But having said that, they were also very careful in their scholarship and in what they prescribed for the proper judicial role. And it wasn't a sledgehammer approach to state legislation, but rather a careful parsing out of the legitimate from the illegitimate. And as I mentioned at the beginning of our conversation, there were legitimate goals that this legislation sought. And the dissenters acknowledged that the state does have very broad police power, as it did under the common law, to arrest public health and safety problems, but that the court should scrutinize the legislation to essentially assure two things. One, that there was a legitimate government purpose, and obviously health and safety is. Lining the pockets of politicians is not. And secondly, is the legislation aimed at the legitimate government purpose? So, for example, regulating how one would dispose of cattle carcasses, the conditions under which cattle would be slaughtered. Those sorts of things are totally fine for the government to regulate. But establishing a single monopoly would be beyond the police power. So the court would have upheld vast portions of the statute while simply saying that it did violate the butcher's right to ply their own trade, to put the entire industry in the hands of a single company. And to me, that's exactly the role that the court should be engaged in, is what is now known as rational basis review with bite, where the court is deferential to the problem solving of a legislative body, but at the same time dubious of the special interest pressures that often go into the making of legislation.
I wanted to ask you, you mentioned, and first of all, let me ask you this question. In the Slaughterhouse cases, was there a bar to, say if I sold meat, I slaughtered meat and processed it, distributed, say from Texas, and wanted to sell it in Louisiana. Was I barred by the statute from doing that because I hadn't used the monopoly slaughterhouse? Do you know?
That's yes, you would be. You could only the only lawful place you could slaughter was at the monopoly.
So was there any thought given to a kind of a dormant Commerce Clause challenge, or was there one made and it was stripped out? Do you know?
I don't recall that there was a dormant Commerce Clause claim made there. And, of course, in those days there was this quaint notion that interstate commerce actually meant interstate commerce. So that made the idea of challenging something that was intrastate commerce might not have occurred even to the most creative lawyers of the day.
You mentioned Scalia's comments earlier about building a case for economic liberty, and this being something that had to happen before courts might become more attuned. And of course, I just finished reading the debate between Justice Scalia and a much younger Richard Epstein on the question of economic liberties and rational basis review. And I'm thinking, is the aversion within widespread parts of, we'll say, the conservative, even many libertarian legal minds, it almost would seem it would go back to Slaughterhouse from the standpoint of one of the consequences of Slaughterhouse, which you talk about in Death Grip, is this attempt to shoehorn it into what I think has to be a linguistically challenged phrase, substantive due process. And of course, there are some recent attempts and some recent scholarship to revive substantive due process as being a protection device for economic liberties. But I'm suspect that you seem highly suspicious of this maneuver. But is that really? That has to be one part of this, that you recognize a wrong's been made, but how now to correct it, and you did it through this process, which left you vulnerable, it seems, to a later attack.
Yes, that's absolutely right. The Supreme Court, starting in the late part of the 19th century and going really all the way into the early years of the New Deal, did try to protect economic liberty under the Due Process Clause, and that met with the condemnation of Oliver Wendell Holmes in his dissenting opinion in Lochner, the Lochner case, and of course met with great derision during the New Deal. And so liberals basically decided that substantive due process, as they called it, was an absolutely illegitimate exercise of the courts. But then the liberals got into the act and used substantive due process to protect privacy rights, the right to abortion, and so forth. And as a result, the conservatives decided that it was a completely illegitimate judicial enterprise as well. So what we now have is a situation where virtually all conservative and liberal judges and academics disdain substantive due process, and any hint of reviving protection for economic liberty is automatically dismissed, especially if it comes under due process. So I think that it's really critical to get your conceptual basis for the protection of economic liberty correct. And Scalia, who I think lost the debate to Epstein, but nonetheless is in a more powerful position to do something about it, basically was saying you can't just come up to the Supreme Court with one of these cases. You're going to get slapped down. You really, really need to do your spade work, both on the intellectual level and on a more public level, which is one of the reasons why we have worked so hard to find very, very sympathetic cases to bring to restore protection for economic liberty, because we want to illustrate that the evisceration of the protection of economic liberty really is harmful to people who are at the very bottom of the economic ladder.
Let me ask you two questions and I just want to get your reaction. So, let's say you prevail on this question. So, is the flip side that we now have a federal judiciary really sitting in judgment of state legislative decisions, regulating a lot of economic matters, commercial matters, because we've got this new doctrine of robust economic liberty. In that case, you kind of have something like, part of Madison's Virginia plan that no one wanted at the foundation of the country, which is, states largely, they have a police power, but they exercise it with one eye on what the federal government could easily do to them. I'm not necessarily suggesting that's a bad thing, but that could easily happen. And of course, I wonder what the response is. We've got to develop something like the 19th century had, which were these common law methods of reasoning about core constitutional provisions, which now a lot of originalists reject and eschew. But it seems to me that something like that reasoning process would have to come in for it not to be an activist judiciary.
Well, I think you're absolutely right. If the court were to protect economic liberty, a rational basis test would apply, which is, I think, far more aggressive than the courts are currently enforcing it, yet still very deferential to legitimate government powers. And I still think that a tie is going to end up on the government's side, that if it's a close case, there will be deference to what the state or local government did. But that still would mark a pretty significant change, where right now, in fact, one time when I was in court challenging one of these things, and the judge asked the lawyer for the local government to explain what their rational basis was for their law, and the lawyer appropriately said, "We don't have to tell you." And that's over broad deference. But I think that if the courts were to strike down a few of the most obnoxious restraints to enterprise, you would see governmental entities being much more careful in their regulation and less responsive to special interest rent seeking, and restrain themselves a little bit, so that we would not need to see huge judicial interventionism. At least that's my hope, and I've seen that happen in other areas of the law, and I think that would be a very, very positive step in this area as well.
Let me ask you this question. You talk towards the end of your book about incorporation, and so as we were talking about earlier with the substantive due process. With regards to incorporating the Bill of Rights, you argue that the privileges or immunities clause would be a much better basis to do this. What evidence do we have, textual evidence, that such was meant for the 14th Amendment clause, that it would actually incorporate the Bill of Rights?
Well, a case was made for this in an excellent book by Michael Kent Curtis called No State Shall Abridge. And I think that the case for protecting the Bill of Rights is actually more difficult than the case for protecting economic liberty, because the Civil Rights Act was the main object to constitutionalize it. But I think that when the framers spoke of the rights of federal citizenship, certainly they were intending to protect the constitutional rights that did exist, and that would encompass the Bill of Rights. So one of the first things that the Supreme Court did after the Slaughterhouse cases was to decide that the Second Amendment was not protected by the Privileges or Immunities Clause either, and so we had just a huge mess with regard to the incorporation of the Bill of Rights as well.
I was curious about that because there's a lot bubbling up on this question, and I always wonder, because going back to our discussion about the common law aspect of privileges and immunities, it just seems a difficult case, and yet the court obviously moved in that direction over the 20th century of incorporation. I wanted to ask you a question about a case involving the Trappist monks in Kentucky. And you mentioned this towards the end of your book as kind of one glaring example of how an industry, or say a company within an industry, can cooperate the state legislature and co-opt the state legislature into doing their bidding for them. And this is in the funeral casket industry, where it seems to be one company effectively put the casket operation of a monastery on hold and is now threatening them with criminal action if they continue to make caskets at a price below what this company wants them to be sold at. Where does this case stand? Do you know?
I am not sure exactly where it stands. It is an Institute for Justice case. I believe that it is still in litigation. But interestingly, the sale of caskets, which has to get past the funeral home monopoly in many states, this is probably the issue that will get to the U.S. Supreme Court, because we have 3 Circuit Court of Appeals decisions on this issue going in 3 different directions, which, as you know, is the usual recipe for getting a case to the U.S. Supreme Court. We have the Sixth Circuit saying that is invalid, that requiring limiting the sale of caskets to funeral homes is unconstitutional. We have the Ninth Circuit somewhere in the middle, although that the restriction it considered it did strike down. But we have the 10th Circuit Court of Appeals holding that economic protectionism is a legitimate government purpose. That, to me, is an invitation to the U.S. Supreme Court to review that doctrine. If that's true, I mean, it's just such an obscene concept in a nation that's doctrinally committed to freedom of enterprise.
No, indeed, we can look forward to that. Clint, I wanted to thank you for being with us today. I've enjoyed discussing your book, Death Grip: Loosening the Law's Stranglehold Over Economic Liberty.
Richard, thanks for having me, and thanks to your listeners.
This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawtalk.org, where you can subscribe, comment, find other episodes, and links relevant to today's conversation. Our email address is mail@libertylawtalk.org.